Task 8 talks about operating as a representative in terms of the FAIS Act. Task 8 has 12 qualifying criteria. Let's look at Task 8, Qualifying Criteria 7. Explain the disclosure requirements for a representative under supervision. We are going to cover the disclosure requirements for a representative under supervision. Remember, depending on the level of supervision, the supervisor may be present when the representative renders financial services to a client, and at other times may not be present but may review the record of financial services subsequently. The disclosure by a representative under supervision is significantly the same as a representative not under supervision. The one main difference is that a representative under supervision must disclose the fact that they are working under supervision. In the following, we will be covering the following sections. First, we start with Board Notice 104 of 2008 relating to representatives working under supervision. In Qualifying Criteria 6, we explained and discussed when a representative should be under supervision, and we covered the period of supervision, selection of the supervisor, the supervision agreement, the supervisor's responsibilities, and the responsibilities of the representatives. Under Qualifying Criteria 7, we are going to have a quick recap on the representative responsibilities. What the representative under supervision must do. The representative must adhere to the requirements of the supervision contract. The representative must disclose to the clients that they are working under supervision. The representative is to provide the supervisor with any records and/or documents regarding the advice given and/or intermediary services rendered. The representative is to request guidance from the supervisor if in doubt when performing any duties in relation to the supervision contract. The representative must undertake the relevant product training and actively pursue the completion of the required qualification within the prescribed time limits. Next, we are going to recap on Section 13 of the FAIS Act, which deals with the qualifications of representatives and duties of FSPs. Here we have an FSP that is made up of key individuals who are effectively in charge of and oversee the FSP, and then you have the representatives. The representatives provide and give the financial advice and/or render intermediary services to the clients. The key individuals also are in charge and oversee the work of the representatives. Just remember, the key individuals take responsibility for the representatives, but for representatives under supervision, the key individuals do not necessarily need to be the supervisor, as we saw in Qualifying Criteria 6. We then have the compliance officer, who is effectively there to watch over and monitor compliance of the FSP with the FAIS Act. Let's now specifically look at and focus on the representative. A person may not act as a representative of the FSP unless, before rendering financial services to a client, the representative should have confirmation certified by the FSP that the representative has a signed contract and/or mandate to represent and act on behalf of the FSP. The FSP accepts responsibility and is liable for the activities of the representative within the scope of the contract and/or mandate. A person may not act as a representative of the FSP unless the representative meets the fit and proper requirements. A person may not act as a representative of the FSP if he or she was debarred, unless he or she has complied with the requirements of registrar to be reinstated. Remember that the registrar, commissioner, and authority are interchangeable concepts that all refer to the same body of the FSCA. A person acting as a representative must not render financial services or contract in the name of anyone else other than that of the FSP they are a representative of. Next, we will recap on Section 3 of the Code of Conduct, which relates to the specific duties of a provider. Remember, a provider is an FSP and/or a representative. When FSPs render financial services, they need to consider what they say to clients, how they contract and deal with the client, and any possible conflicts of interest. First, we cover representation. Representations are what is said to the client, and the information provided by FSPs must meet specific requirements. Second, we cover conflicts of interest. FSPs must always be aware of conflicts of interest and put in place a conflicts of interest management policy to help them manage this. Third, we cover contracted. The FSP must render a financial service in terms of a contractual relationship, making sure everything is done properly and on time. The FSP must keep records, and we will look at what and how and for how long these records must be maintained. The FSP must also not disclose confidential client information without the written permission and consent of the client concerned. Let's have a look into all the details surrounding this as well. Let's look at representation in detail. As mentioned, representations are what is said to the client and the information provided by the FSP. Representations must meet the following 8 specific requirements. 1. Be factual. Representation and information provided must be factually correct. 2. Must be easy to understand by the client. Representation and information provided must be in plain and understandable language. 3. Must be at an appropriate level. Representation and information provided must be adequate and appropriate, based on known or reasonably assumed level of knowledge of the client. 4. Be timely. Representation and information provided must be provided timelessly, so client has enough time to make an informed decision. 5. Be in writing if requested. Representation and information provided may be provided orally, but must be in writing if requested by client. 6. Be in readable print. Representation and information provided must, when provided in writing, be in readable print. This refers to size of font, spacing, etc. 7. Amounts to be in rand values. Representation and information provided must reflect amounts in monetary terms, therefore South African rand values. If amounts can't be reasonably determined, then a description of the calculation must be adequately described. 8. Information must be repeated if significant changes happen. Representation and information provided does not need to repeat or duplicate information unless material or significant changes affect the client. Next, let's focus on the conflict of interest in detail. As mentioned previously, an FSP must always be aware of conflicts of interest and put in place a conflict of interest management policy to help management in managing this. Any conflict of interest between the FSP and the client or the representative and the client must be avoided or reduced where it cannot be avoided. An FSP or its representative must inform the client of the conflict of interest management policy and how the client can access it. So an FSP must have a conflict of interest management policy document prepared and available for the client to read. Where a conflict of interest has arisen, then as a minimum requirement, the following must be disclosed. 1. What measures will be taken to avoid or reduce the conflict? 2. What ownership interest or financial interest, other than immaterial financial interest, that the FSP or representative may be or has become eligible for or entitled to? 3. The nature of any relationship or arrangement with a third party that gives rise to a conflict of interest, in enough detail for the client to know and understand the exact nature of relationship and conflicts of interest. Let's now turn our focus on contracting in detail. As mentioned previously, the FSP must render financial service in terms of a contractual relationship, making sure everything is done properly and on time. Services must be rendered as per the contract and reasonable requests from the client. Action of the contract or request from the client must be executed as soon as reasonably possible. The client's interest must be reasonably considered over the interest of the FSP. Transactions of the client must be accurately accounted for. Now let's take a look at the FSP's duties when it comes to keeping of records. One of the most important requirements in the FAIS Act. The FSP must keep records, and we will look at what, how, and for how long these records must be kept and maintained. The FSP must have systems in place to record, store, retrieve, and safeguard the documents of its clients. The FSP does not have to physically keep the records themselves within their premises, but they must have access to retrieve or made available to them within 7 days of the registrar's request. Therefore, the FSP has 7 days to retrieve records from its third party that stores on its behalf. The FSP must keep client records for at least 5 years after termination of products or rendering of the financial services. Therefore, the FSP must safeguard clients' records for at least 5 years after the termination of a relationship with that client. The FSP can keep records in an appropriate electronic or recordable format that can be reduced to writing or printed. What's the FSP's requirements with regards to disclosing clients' information? The FSP must not disclose confidential client information without the client's written permission or consent. Let's look into all the detail surrounding this confidentiality. Confidential information about a client or a product supplier cannot be shared unless or except written permission and consent is obtained first, or required in the public interest, or required under any law. This applies to information received from the client or from a product supplier in regard to such a client or product supplier. But it is important to remember that under Section 4, subparagraph 1, the FSP has a duty to provide a client with information of the product supplier. The following is required to be disclosed about the product supplier to the client under Section 4, subparagraph 1. If information is provided verbally or orally, then it must be reduced into writing within 30 days. The product supplier's information, its name, address, and contact details. The product supplier's information being its name, contact details of its compliance officer, and complaints department. The FSP's contractual relationships with the product supplier. Any conditions or restrictions imposed by the product supplier with regards to the type of products or services that can be rendered by an FSP. Lastly, where the FSP holds an interest in the product supplier. An interest in a product supplier is considered to be more than 10% of the shares or equivalent in the product supplier, or more than 30% of the remuneration received in the previous 12 months from the product supplier. So we have gone through the whole of Section 3 of the Code of Conduct, dealing with the specific duties of the FSP. Next, we will recap on Section 3A, which deals with financial interests and conflict of interest management policy. Section 3, capital A, relating to the financial interest of the FSP and representative, is basically dealing with what and how the FSP and representative can pay and or earn from providing financial advice. This section also covers the conflict of interest management policy, which is basically how the FSP and representatives must manage conflicts of interest. Here we look at the financial interest of the financial service provider and representatives. These paragraphs highlight what the FSP and representatives can receive or pay in terms of compensation. An FSP and or its representative may only receive or pay financial interest from or to a third party. Here it is important to highlight that these subparagraphs relate to a third party and not between the FSP and its own representatives. Commissions. As outlined in the Long-Term, Short-Term Insurance Act and Medical Schemes Act. Fees. As outlined in the Long-Term, Short-Term Insurance Act and Medical Schemes Act. Agreed upon fees, where the fees and commissions are not paid in terms of the Acts, but can only be paid or received if those fees are agreed upon in writing by the client, and the client can stop the payment of the fees at any time. Fees or remuneration are for rendering of a financial service to a third party, which must be reasonable to compensate for the service rendered. Immaterial financial interest basically allows for the payment of immaterial financial interests. Financial interest. As much as it's not covered above, it's equal to what is considered and or deemed reasonable compensation if it was to be paid as fees or remuneration. An FSP may not offer any financial interest to its own representative for the following reasons. Based on quantity of business done with no consideration of quality. Giving preference to a specific product supplier or product providers over other product suppliers or product providers. Giving preference to a specific product over other products that do not address the need of a client. Basically, a representative cannot be compensated in any way for selling a lot of financial products without considering the quality of advice, as well as giving preference to specific financial products of specific product suppliers or product providers. This is to ensure proper advice is given without personal interest or motive of the FSP and or representative. For the purpose of this section, it is important to note that where an entity is an FSP as well as the product supplier, then paragraph A would not apply to the representatives of the entity. However, paragraph B would be applicable. Therefore, if the product supplier and the FSP are the same company, then paragraph A does not apply to the representative of that entity, but paragraph B applies. Section 3A, subparagraph 1A. This section deals with sign-on bonuses for Category 1 FSPs. Subparagraph A states, a Category 1 financial services provider, FSP, that is authorized or appointed as a key individual or representative to give advice may not receive a sign-on bonus from any person. Subparagraph B states, no person may offer or give a sign-on bonus to any person other than a new entrant as an incentive to become a Category 1 financial services provider that is authorized or appointed as a key individual or representative to give advice. Subparagraph A basically states that Category 1 FSP authorized to give advice cannot receive a sign-on bonus from any person. Subparagraph B basically states cannot offer a sign-on bonus to become a Category 1 FSP that gives advice. Basically, cannot receive and or offer a sign-on bonus to give financial advice. One exception is that a new entrant can receive a sign-on bonus as long as they are not already registered and or authorized as a Category 1 FSP that gives advice. We refer to Category 1. What are categories? Categories are different types of licenses that an FSP can be authorized for. Here we have Form FSP2, which is the license category form. This form is what an applicant would complete when applying for the different licensing categories. Note that it's an applicant and only becomes an FSP when authorization has been granted. We will take a look at this form in order to explain the different license categories. Here we can see there are 5 types of license categories. Category 1, 2, 2A, 3, and 4. In the newest version of the FSP2 form, there is no description of the categories. Therefore, we can have a look at the previous version of the form for these descriptions. The FSCA license categories form is a good place to understand the different types of categories that an applicant FSP can be authorized for. We refer to the previous version of the FSP2 form, which provided explanatory notes of the different categories. First, we look at Category 1. Category 1. This is more like the general category. The applicant, FSP, will indicate what financial products and financial services it wants to render and wants authorization on in terms of giving advice and/or render intermediary services. Simply put, Category 1 is basically the only category in which giving advice and/or rendering intermediary services is applied and granted authorization for. Category 2, 2A, 3, and 4. These are specialized categories of FSPs in terms of providing and rendering financial services, specifically intermediary services. Category 2 is known as a discretionary FSP. Category 2A is known as a hedge fund FSP. Category 3 is known as an administrative FSP. Category 4 is known as an administration for assistance business FSPs. Here we see Category 1 that is split into different financial products, also known as subcategories. Here are different types of financial products and subcategories that an applicant FSP can register, apply, and be authorized for. It is important what an applicant FSP can register, apply, and be authorized for. This will depend on whether they have the experience and qualifications for that category, subcategories, and products. You will see in Task 8 how important it is to evaluate if a representative is fit and proper before being appointed, because they also must meet those requirements of experience and qualifications per category, subcategory, and products. Here the applicant FSP will indicate the financial product or products that it wants to render financial services on under advice and/or intermediary services. It is important to know that what the applicant FSP can register, apply, and be authorized for will depend on what experience and qualifications they have. They must have key individuals that have the relevant qualifications and experience available to provide and render the services they apply, register, and are authorized for. Here are the different financial products and or subcategories that an applicant FSP can apply, register, and be authorized for. These financial products are specifically related to the type of specialized category they fall under. Here you can see there is only one column, and that's because as stated previously, Category 2, 2A, 3, and 4 are specialized categories of FSP in terms of the services they provide and render, and are only intermediary services and cannot be advised. It is important to note that what the applicant FSP can apply, register, and be authorized for will depend on the experience and qualifications they have. It must have a key individual or key individuals that have the relevant qualifications and experience available to provide and render the financial services. FSPs can be registered and authorized in more than one category. Therefore, an FSP can be authorized for Category 1 and 4 if the fit and proper requirements of those categories are met. Next, we will look at the Conflict of Interest Management Policy in more detail. An FSP must adopt, maintain, and implement a conflict of interest management policy. The conflict of interest management policy must include a conflict of interest management policy, which should cover how to identify a conflict of interest, and how to avoid, and if unable to avoid, then reduce a conflict of interest, and what to disclose about the conflict of interest, and what processes and procedures need to be followed to ensure compliance with policy, and the consequence of non-compliance. The conflict of interest management policy is to include the type and basis on which a representative will qualify for financial interest that the FSP will offer and how it complies with the Act. A list of all associates and names of third parties include ownership interest, and the conflict of interest management policy must be easy to understand. Owners of the FSP must adopt the conflict of interest management policy. This policy must be approved and implemented. The FSP must make sure everyone is aware of the contents of the conflict of interest management policy. This is usually done through training and awareness. The FSP must continuously monitor compliance with the policy and review the policy annually. The FSP must make the policy easily available to the public. Section 3A, paragraph 3 states that a financial services provider or its representative must not avoid, limit, or circumvent or attempt to avoid, limit, or circumvent compliance with this section through an associate or an arrangement involving an associate. Basically, an FSP or representative must not avoid or limit compliance with regards to a conflict of interest management policy. Section 3A, paragraph 4, covers the report to the registrar, or also known as the commissioner, on the conflict of interest management policy. Subsection 4, paragraph A states, a compliance officer must include a report on the provider's conflict of interest management policy in the compliance report that will be submitted to the registrar or commissioner as required under the Act. Where an FSP need not, as per the Act, appoint a compliance officer, the FSP has to provide the conflict of interest management policy in its compliance report that will be submitted to the registrar or commissioner as required under the Act. Basically, the FSP must include a report on the conflict of interest management policy in the compliance report that must be submitted to the registrar or commissioner. Subsection 4, paragraph B states, the report referred to in paragraph A must report on at least the implementation, monitoring, and compliance with, and the accessibility of the conflict of interest management policy. Basically, the FSP must report on the implementation, monitoring, compliance, and accessibility of the conflict of interest management policy to the registrar or commissioner as part of its annual compliance report. Next, we will recap on Section 4 of the Code of Conduct, which deals with information on the product supplier or product provider that should be disclosed to the client. The FSP has a product supplier, or also known as the product provider. The product supplier or product provider provides the financial products which the FSP gives advice on to his or her clients. The product supplier or product provider can be a third party as shown, but can also be the FSP itself. So in summary, an FSP could have an external product supplier or product suppliers, as well as also being a product supplier to itself. The FSP gives advice to clients on different products from different product suppliers based on the needs of the client. The FSP therefore must notify the client in writing about relevant information about the product suppliers or product providers within 30 days. So we need to understand what an FSP needs to inform its clients about in order to comply with Section 4 of the Code of Conduct. So we need to make sure our clients know who the product supplier is and their contact details. Therefore, we must provide the client with 1. The product supplier's name. 2. The product supplier's physical address. 3. The product supplier's postal address. And 4. The product supplier's telephone number. This may seem basic, but it is important that it's done, so the client has all the information he or she needs to know, and providing this information can easily be overlooked. Next, it is important that the FSP informs the client of the contractual agreement and relationship with the product supplier. This is so the client is aware of the FSP and the product supplier's relationship. We need to provide the names and contact details of the product supplier's compliance departments. An FSP must communicate to its client any conditions or restrictions that have been imposed by the product supplier with regards to the type of financial products or services that they as the FSP have rendered. All these are important as they provide the client with an understanding of the relationship between the FSP and the product supplier, so that the client can make an informed decision knowing that the FSP and the product suppliers have a relationship and an agreement with each other. Here we see that when there is a financial interest held by the FSP with the product supplier, the FSP must communicate and disclose this fact to the client. If the FSP holds more than 10% of the product supplier's shares directly or indirectly. So when we say directly, that would mean the FSP holds the shares in the product supplier. When we say indirectly, it would mean that we hold the shares in some other way, either through another company or person. It is also important to see that the Code of Conduct extends this to also say or equivalent substantial financial interest. So basically saying that it does not have to be through holding of shares, but if there is a financial interest that is equivalent to holding 10% of the product supplier's shares. The consideration of financial interest also states that if over the past 12 months, the FSP has received more than 30% of its total remuneration from product supplier. These sections are basically there to ensure that the client knows that the FSP has some sort of significant financial interest in the product supplier, so they can at least be aware of that fact when making their decisions. Here is where things can get a bit complicated. Let's roleplay this. Now say we are an FSP as well as a product supplier, and as a product supplier, we also have other FSPs selling our products through some sort of contractual relationship and/or agreement. Then it only stands to reason that we as the product supplier would need to provide all the information we have talked about to this contracted FSP so they can communicate it to their client. Here we can see that we have multiple FSPs that are also product suppliers and have insurance companies that are only product suppliers. An FSP can be giving advice to their clients on products and services from some or all the product suppliers based on the client's need. An FSP can provide and/or render financial services in respect of a choice of financial product suppliers. The FSP must exercise judgment objectively in the interest of the client concerned. This is very important. As we can see from this section, we as the FSP want to inform and notify the client of the FSP's relationships with product suppliers in order to ensure objectivity is maintained and that the interest of the client is always maintained. It is important that the FSP does not make unfair comparisons. So the code states that the FSP may not compare different financial products, product suppliers, product providers, FSPs and/or representatives unless the different characteristics are clearly made. It is important to note that if any comparisons are made, then they cannot and must not be inaccurate, unfair, or unsubstantiated criticism. Next, we will recap on Section 5 of the Code of Conduct, which covers information an FSP and representative must disclose to the client. Section 5 of the Code of Conduct covers what the FSP must provide and disclose to the client about itself when rendering a financial service. Each of the paragraphs of Section 5 cover the information an FSP must provide and disclose to the client when rendering a financial service. The FSP is to provide the client with full particulars of the information we are going to discuss. If this information is provided verbally, then the FSP must provide it in writing within 30 days. The FSP is to disclose to the client its full business names and trade names, its registration number, its postal and physical address, its telephone numbers, its internet and email address, the names and details of contact persons, and the names and contact details of its compliance officer. The FSP is to provide details of its legal and contractual status and its relationships and agreement with product suppliers. This is to make sure that the FSP makes it clear to the client as to who accepts responsibility of the actions of the FSP and/or representatives in rendering financial services and the extent to which the client must take responsibility. The FSP is to provide names and contact details of its compliance officer and details of its compliance department. And for representatives, the names and contact details of the FSP that the representative is contracted to. The FSP is to provide details of the financial services and financial products it is authorized to render and provide in terms of its license and any conditions or restrictions. The FSP is to disclose if it holds and/or has in place guarantees, professional indemnity or fidelity insurance cover or not. The FSP is to disclose whether a representative is providing and/or rendering financial services under supervision as defined by the definition of fit and proper requirements. Any exemption provided by the registrar allowing the FSP not to disclose any of this information must be disclosed to the client by the FSP. Next, we will recap on Section 7 of the Code of Conduct, which covers information about financial services that needs to be disclosed to the client. This section deals with the information that an FSP must provide the client with regards to the financial service they are rendering. When an FSP gives advice to the client, the FSP must disclose and provide certain information relating to the financial services being rendered. The FSP must inform the client of their responsibility in terms of providing accurate information. It is important to remember that the client provides the FSP with certain information in order for the FSP to provide and/or render a financial service. Therefore, it is important that the information received from the client is accurate as well. Otherwise, the FSP cannot give the correct advice or financial service. It is also important to note that an FSP may not request the client to sign any written or printed documents unless all the required information has been included or sign a blank document. So here we can see that this sets up the relationship between the parties. The client must give accurate information, and the FSP cannot ask the client to sign anything unless the FSP has provided all the required information per Section 7. The FSP must, at the request of the client, provide a statement of account in connection with the financial service rendered to the client. The FSP must provide a client with a statement of identifying and listing financial products still in existence at least annually. This statement must include specific information. We will explore this information a bit later. Let's start with: When the FSP gives advice to the client, they must provide certain information relating to the rendering of the financial service provider. We can divide this information into 3 categories. 1. General explanations. 2. Material information. 3. Specific disclosure. In terms of general explanations, the FSP is to provide the client with reasonable and appropriate general explanations of the nature and material terms of the contract and the transaction. The FSP is to provide full, frank, and honest disclosure of information that is reasonably expected to be disclosed to enable the client to make an informed decision. In terms of material information, the FSP is to provide the client with material contractual information, facts, illustrations, projections, or forecasts that they have. In terms of specific disclosure, Section 7 of the Code of Conduct goes into detail as to what needs to be disclosed. Section 7, paragraph 1c states, the following information must be disclosed at the earliest reasonable opportunity and time. 1. The name, class, or type of financial product. 2. The benefits of the financial product and how they are calculated, accrued, and paid out. 3. The specific information for financial products marked as an investment product or has an investment component. 4. The obligation to the product provider, nature, extent and frequency of monetary obligation and escalation, increases or additions. 5. The obligation to the FSP, nature, extent and frequency of monetary obligation. 6. Any special terms and/or exclusions. 7. Any guaranteed minimum benefits. 8. How accessible will the funds be? 9. Any early termination consequences. 10. Tax implications. 11. The cooling off period. 12. The nature, extent and frequency of payment of commission, fees and/or brokerage fees. 13. Any and all risks associated with the product. 14. The amount of the increase in premiums over the first 5 years, then the basis of the increase over years 6 to 20 years, not exceeding 20 years. Section 7, paragraph 1c, subsection 3 states that specific information for financial products marked as an investment product or has an investment component needs to be provided and disclosed. Therefore, when a financial product has an element of an investment, then there is additional disclosure requirements that need to be provided to the client about the financial product. Let's go through these disclosures. Firstly, the fees being levied in terms of 1. The amount and frequency of the fees. 2. Who receives the fees. 3. The services or purpose of the fees. 4. Fees based on performance. Then we must include the frequency, performance measure period, and/or other criteria. And 5. Where the structure of the investment has other underlying financial products, then we must include the manner in which the client can determine the net value of the investment. Next, we need to disclose how the value of the investment is calculated and the details of the underlying of other financial instruments. We need to disclose the details on the past performance of the investment as well. 1. On request of client. 2. Over intervals that are reasonable for type of product. And 3. Include a warning that past performance is not an indicator of future performance. We also need to disclose the details of any rebate on fees passed on to the client. Lastly, any platform fees that are being charged to the client. So now we have covered all the elements relating to when the FSP gives advice to the client. What information the FSP must provide or disclose when rendering the financial service. In terms of specific disclosure, Section 7 of the Code of Conduct goes into detail as to what needs to be disclosed. We will now cover facts that the FSP must tell and inform the client of the client's, responsibility in terms of providing accurate information. It is the client's responsibility to ensure all facts disclosed are accurate and complete. Any information completed and submitted by the FSP, the client must ensure it's accurate and complete. The FSP must inform the client of possible consequences of misrepresentation or non-disclosure. Simply put, the results of giving incorrect and incomplete information. The FSP must supply the client, on request, a copy or record of any transaction requirements within reasonable time. So we have seen that the client needs to ensure that they provide the FSP with accurate information and that any information that is used by the FSP is accurate, because any misrepresentation or non-disclosure could have an adverse effect on the advice given and or provided. Next, we cover the fact that an FSP must provide a client with a statement of identifying, listing, and mentioning products that are still in existence at least annually. This statement must include specific information. This specific information is obligations, the ongoing monetary obligations of the client. Benefits, the main benefits provided by the product. Value of the investment, if any. Where a product has been identified as an investment or has an investment component, then the net value of that investment to the client must be disclosed. Commissions and fees. Any ongoing incentives, commissions, fees, and brokerage fees payable to the provider must be disclosed. This statement need not be provided where the client is aware or should be aware that the FSP does not render or has stopped rendering ongoing financial services in respect of the products concerned. We have now covered all of Section 7, dealing with the information that the FSP must provide the client with regards to the rendering of the financial service. Note that this section is long with a lot of details, so make sure you go through it and understand all the requirements laid out. Next, we cover Section 8 of the Code of Conduct, which outlines the information an FSP must obtain from the client before giving financial advice. Before giving advice to a client, an FSP must take steps to get from the client all available information about the client's situation, financial product experience, and objectives to enable the FSP to provide the client with appropriate advice. The FSP must then conduct a financial needs analysis, F&A for short, based on this information provided by the client in order to give advice. From this analysis, the FSP will identify the financial products that will be appropriate and suitable based on the client's risk profile and their financial needs. This will, however, be subject to any limitations by the Act or existing contracts. Once the FSP has identified financial products, the FSP must then take steps to determine if the financial products identified wholly or partially replaces an existing financial product or products held by the client. Take note that when existing financial products are to be replaced by new financial products, there is some disclosure that needs to be made. So, as mentioned earlier, where the financial product or products held by a client is replaced, wholly or partially, the FSP should fully disclose the actual and potential financial implications relating to costs and consequences of such a replacement, including, where possible, the following: difference in fees and charges between the products, special terms and conditions which may be applicable to the replacement product as compared to the terminated product. Examples of these special terms and conditions may be exclusions of liability, waiting periods, loadings, penalties, excesses, restrictions, and circumstances where benefits won't be provided. Impact of age and health changes on the premium to be paid. Difference in tax implication. Material differences between the investment risk of the replacement product and the terminated product. Penalties or unrecovered expenses deductible or payable due to termination of product. To what extent the replacement product is readily realizable or relevant funds are accessible compared to the terminated product. Vesting rights, minimum guaranteed benefits or other guarantees or benefits that will be lost as a result or consequence of the replacement product. Any incentives, remuneration, consideration, fees received directly or indirectly by the FSP in relation to the financial services offered for either or both the terminated and or replacement products. The FSP must take reasonable steps to ensure that the client understands the advice given and is in a position to make an informed decision. This is very important. Where an FSP provides and gives advice to replace an existing long-term insurance contract, agreement, or a policy with another financial product, the FSP must notify the product supplier of the existing and the replacement long-term insurance contract, agreement, or policy of such advice. It is important to note that this notice must be made after the advice was given, but before replacement contract, agreement, or policy document has been submitted by the FSP. Where the client has not provided and or disclosed all the necessary information to the FSP, or the FSP has not had sufficient time to conduct a complete financial needs analysis. The FSP should inform and notify the client and ensure the client fully understands that a full analysis could not be performed. There may be limitations on the appropriateness of the advice provided. The client should take care to consider whether the advice is appropriate, considering the client's objectives, financial situation, and particular needs. Where the client chooses to elect a transaction or financial product different from the one recommended by the FSP, or elects not to follow or take the advice of the FSP, or wants more information than what the FSP can provide. The FSP must notify the client of the risks and advise the client to take care that when selecting or choosing any product that he or she consider his or her needs, objectives, and circumstances. That concludes Section 8 of the Code of Conduct, covering the process that the FSP must follow when furnishing or giving advice to a client. Lastly, we will recap on Section 9 of the Code of Conduct that deals with the record of advice that must be maintained and provided to the client. The FSP gives advice to the client. An FSP must keep a written record of the basis on which this advice was given. Only needs to be kept this record where the FSP is aware that the financial product was taken based on the advice given as set out in Section 8. The record of advice must include the following: a summary of the information and material on which the advice was based on, the financial products that were considered, the financial products that were recommended with an explanation of why the products were selected are likely to satisfy the client's needs and objectives. If the recommended financial product or products is replacing an existing product, then an FSP needs to provide details on the comparison between the two products in terms of fees, charges, terms and conditions, waiting periods, penalties, excesses, restrictions, etc. The reasons why the replacement is considered more suitable to client needs rather than modifying or terminating the product. The FSP must give the client a copy of the advice in writing. We have now covered all the sections relating to the disclosure requirements for a representative under supervision. We will now go through some possible questions. Question 1. Jason is working under supervision for 2 years. A client complained about the advice she received 6 months ago from Jason and said she was not told that he was working under supervision. Diane is Jason's supervisor. What could have been done to avoid this? A. Diane should have informed the client that Jason is working under supervision. B. Diane should have overseen the advice that Jason had given the client. C. Jason should have given the details of Diane to the client. D. Jason should have disclosed to the client that he is working under supervision. Pause the video here if you need some time to read over the question and think about your answer. The correct answer is option D, being that Jason should have disclosed to the client that he is working under supervision. As Jason had been working for 2 years under supervision, he would be under ongoing supervision and not direct supervision. Therefore, Diane would not have been checking everything that Jason was doing. But it would be important for Jason to let the client know that he is working under supervision so that the client was aware. Question 2. Carla is a supervised representative. Which of the following are her duties? A. Carla must comply with the provisions of the supervision agreement. B. Carla must actively pursue completion of class of business training, regulatory examinations, and recognize qualifications within prescribed times. C. Carla must disclose to the clients that she is rendering financial services under supervision. D. All of the above. Pause the video here if you need some time to read over the question and think about your answer. The correct answer is all of the above. Option D. Question 3. Mohau wants to purchase shares. Mohau only has grade 10 education and is a retired pensioner with little to no understanding of financial investments. Mohau approaches Musa, an investment advisor at Capitec, to assist him in purchasing shares. Mohau wishes to invest a sum of 10,000 Rand and seeks a stable, non-volatile share option to invest in. Choose the correct options below. 1. Musa must provide Mohau with a detailed written analysis of the various share options available for purchase. Musa has a duty to point out opportunities to purchase hedge fund instruments, swaps, etc. 2. Musa must establish Mohau's financial situation and financial experience. 3. Musa is correct in recommending highly volatile oil shares, as her advice is that Mohau will make loads of money quickly, as his 10,000 Rand will not get him far. 4. Musa must choose and/or recommend a product which is suited to Mohau's financial situation and risk profile. Choose between option A, B, C, and D. Pause the video here for a few minutes and read through the question and options provided before answering the question. The correct answer is option D. Statements 2 and 4. Statement 1 and 3 are not correct because Musa should be considering that Mohau is retired and not educated in financial investing, and therefore it would not be appropriate to provide Mohau with such risky options. Question 4. Disclosure requirements are probably one of the most important aspects of a financial service that an FSP renders to its clients. As a representative, you need to understand what is required from you in terms of disclosure. Which of the following disclosure requirements must be adhered to? A. There must be adequate disclosures on the product supplier. The disclosure must include the name, physical location, postal and telephone contact details of the product supplier. B. Disclosure of the product supply information must state the contractual relationship between the FSP and the product supplier to disclose whether the FSP has contractual relationships with other product suppliers. C. A representative need not disclose that he or she is rendering services under supervision. D. Representatives need not disclose detail about the legal relationships between the FSP, product supplier, and representative. Pause the video here and read through the question before deciding on your answer. The correct answer is option A. There must be adequate disclosure on the product supplier. The disclosure must include the name, location, and contact details of the product supplier. It is important to use the questions that are covered and that you do as learning opportunities. Take time to read through the questions and understand what they are asking, and learn from your mistakes. Question 5. Kanye is up late studying for her RE5 exam, but she is not sure what the representative must disclose to clients as soon as possible. She asks if you know the answer. 1. Detail about the legal relationships between FSP, product supplier, and representative, if any, so that it is clear to the client who accepts responsibility for the actions of the FSP or representative, or the extent to which the client must accept such responsibility. 2. Names and contact details of the relevant legal departments, or in the case of a representative, the contact details of the representative. 3. Details of the financial services which the provider is authorized to provide and of any conditions or restrictions applicable to the license, and whether the FSP has guarantees or professional indemnity or fidelity insurance cover or not. 4. Whether a representative of a provider is rendering services under supervision as defined in the determination of fit and proper requirements. You must choose between option A, B, C, D, or E. Pause the video here for a few minutes and read through the question and options provided before answering the question. The correct option is D. If you did not get the correct answer, then make sure you go back to the material as well as use the questions as learning opportunities in preparation for your exam. So let's go through a final overview of what has been covered. There are a number of sections that were covered in previous qualifying criteria and repeated again in this qualifying criteria. In summary, this qualifying criteria covered the disclosure requirements by a representative under supervision. So the starting point is that the representative must disclose the fact that they are working under supervision to the client before they provide any financial service. After that, the sections relating to disclosure are basically the same for a representative working under supervision and a representative not working under supervision. We hope you enjoyed the video and learned a lot. Please make sure to check out our other RE videos.